To this now. This month, the country marks several key milestones, among them the 30th anniversary of the founding of the Constitutional Court, a pillar of our democracy and a beacon of the constitutional promise. Over the past 3 decades, the court has handed down landmark judgments that have reshaped our nation's approach to justice and human rights. From the Grootboom housing case to the Treatment Action Campaign ruling on access to medicine, these decisions have set powerful legal precedent in the fight for socio-economic rights. Yet, despite these judicial victories, the struggle to secure access to basic rights, especially in education, health and housing, remains urgent and unresolved in many respects for many South Africans. So let's reflect then on the Constitutional Court's journey of 30 years, as well as how its jurisprudence has bent the arc of the country's moral and rights universe, perhaps towards a more just society. I'm joined now by constitutional law expert Tanvir Jiwa, as well as human rights activist Mark Haywood. Good afternoon to the both of you, and thank you for your time. So let me start with you, I suppose, Mark, just because the introduction speaks to socio-economic rights, but those are not the only rights in the Constitution, and certainly not the only rights that have been subject to litigation and decision-making in the Constitutional Court. But it's been a big part of your story, a big part of the Constitutional Court's story. Tell me what your reflections are about the importance of the Constitutional Court in cementing those rights.
Good afternoon, Tulas. I think the Constitutional Court over these 30 years has played a very, very important role at key moments in relation to socioeconomic rights. And when we're talking about socioeconomic rights, as you've said, we're talking about rights to food, rights of access to healthcare services, rights to basic education, rights to housing. And those rights have been firmly and well articulated in paper as obligations that are imposed on the government. But I think the challenge that we still face is that there's a massive gulf between our constitutional rights on paper and what the Constitutional Court has said very frequently, and the actual practice of government and the ability of the Constitution to reach into the lives and the homes of the poorest of the poor in our country. You know, you were just showing those shocking stories a few minutes ago that show the conditions in which many people live without proper housing still 30 years later. So really, the ultimate test of the durability of the Constitution, of its legitimacy in the minds of 60 million people in South Africa, will be the degree to which it delivers meaningful change. Yeah. But at key moments, it has brought about that change. You mentioned the Treatment Action Campaign case. You know, I would say with the TAC case that judgment from the Constitutional Court in 2002 has actually contributed to saving, several million lives directly. So if we use the Constitutional Court properly, if we make sure its judgments are implemented, then it is a game changer.
Yeah. Tanvir, let me bring you in. And I do want us to get to the content of the jurisprudence and how it has evolved in the Constitutional Court. But I don't want to lose the importance as well of the romanticism of it all, right? After all, the doors of the Constitutional Court were first flung open by the late former President Nelson Mandela, and it was on the 14th of February, 1995, which was Valentine's Day. But just talking about the symbolism, the romanticism, and the importance of it all, how important is the Constitutional Court as a piece of architecture, as part of the architecture of our democracy?
Thank you so much for having me. Firstly, it's extremely crucial to look at the Constitutional Court in the grand scheme of things, especially when you look at other democracies around the world, right? I think a lot of us constitutional lawyers also look at the US, for example. And when you look at the US Supreme Court, I think a lot of us can take a step back when we criticize the Constitutional Court, because we look at the judgments recently and we look at what it has been doing in actually stopping the executive, and we really take a step back and we look at the Constitutional Court and we look at all of the steps it has taken in actually stopping the executive from really being so corrupt, and in many steps, for example, even with the TAC cases, and also with, for example, the case we always talk about is Nkandla, with the President Zuma era as well. In a lot of the times, even with socioeconomic jurisprudence, we have truly seen the impact that the Constitutional Court has been able to have in allowing the jurisprudence to evolve over the last 30 years. We've been able to see that truly, even though the current state of affairs in South Africa is honestly not the best, as we've seen the deplorable news today and every single day with the depressing state of affairs, we've also seen that honestly, without the Constitutional Court, things would have probably been much worse. So although things are honestly not where it's at, we can say that without the Constitutional Court, things would have probably been much, much worse.
Let me stick with you for a moment, Tanvir, and try and bring this conversation to a level that an ordinary South African will understand, right? You and I talk about the Constitutional Court, and we say it's the product of a supreme constitution that is the standard against which you test all other law and any other conduct by anyone wielding power in society. What does that mean for someone who's sitting at home and wondering, how has the citadel of power, where people sit in gowns and argue endlessly, how has it changed my life? What would be your best answer to that question?
I think the easiest way I always explain this to my students is always to think back to apartheid, right? During apartheid, you had something called parliamentary sovereignty. And what that simply meant is that when parliament made a decision, when it made a law, you were not able to test that law and what that law said against a higher power. And when Parliament made a decision, you weren't able to test the decision and that substance of the decision against a higher power. However, now in this day, you no longer have a parliamentary sovereignty. What you actually have is the constitutional supremacy. What you just said, the Constitution is supreme, and you have that in Section 2 of this Constitution. And what that essentially says is, if today Parliament makes a decision, or anyone in Parliament makes a decision, or Parliament makes a law, what in essence happens is you can test the decision, you can test that law against a supreme law. And that supreme law is the Constitution. That's where you go at the end of the day. You go to the High Court or you go to any other court, but you end up at the Constitutional Court. And in essence, you say, is that law constitutional? Is that decision constitutional? And in essence, all of us here in South Africa, we have rights, and our rights are protected by the Constitution. Under apartheid, not all of us in South Africa had rights, as you will all know better than me.
Mark, I suppose you'd also want to have a crack at this question. An ordinary South African who says, I'm not a lawyer. Half the time, I don't even know what you guys are talking about. You keep talking about jurisprudence. You talk about all these big concepts. How has this Constitutional Court changed my life as an ordinary South African? Can I propose to you that perhaps that's a question that in a way is best answered by positing the counterfactual, what it would have looked like in the absence of the Constitutional Court and the Supreme Constitution? Are you able to argue further on that?
Well, Tulas, I'm a great supporter of the Constitution, and I use it every day in my advocacy and work on social justice. But I can't romanticize it.
Yeah.
If I have to answer your question honestly, I have to say that most South Africans would say that when it comes to their day-to-day living conditions, the Constitution has made very little tangible difference. There are 20 million people in our country who face hunger, and yet there is a constitutional right to sufficient food. There are still millions of people who do not have adequate housing, and yet there are constitutional rights to adequate housing. And that is what people measure the Constitution by. You've got to be honest. And there are millions of people in our country, particularly the poorest people, who don't understand the Constitution and the power that the Constitution gives us when it comes to government and government policy. Research has found that something like 50% of people don't even know that there's a Bill of Rights. And if they do know that there's a Bill of Rights, they don't know what the rights are or how to enforce those rights. So we have a very, very long way to go. And the thing that troubles me, Tulas, is that I don't think our government follows the Constitution when it comes to socio-economic rights. The courts have held the government very tightly to the law and the Constitution when it's about corruption, when it's about rights of assembly, rights of protest, what we call civil and political rights. But over the last 10 years, government has gone backwards when it comes to socio-economic rights through policies such as austerity. And it has also failed to take positive measures. I heard you mention this earlier on. We're a country with gross inequality, but nothing is being done to tax the ultra-rich. Whereas I think that that's probably a constitutional obligation on government to raise the resources so that it is able to impact on people's day-to-day lives.
Yeah, Tanvir, let me give you the parting shot on this one then. Talk to me about the moment we're in right now and what your reflections are about the Constitution, which of course led us to this conversation about the Constitutional Court. Just recently there was this Constitution review process that was taking place in Parliament, and by all accounts it didn't really garner the amount of public participation that we would have liked, right? And I think that talks to to a certain extent perhaps the publicity that was afforded that, and perhaps just the levels of engagement that people feel towards those processes. But having said all of that, we have the national dialogue coming up as well. Is it time for deeper and thorough-going conversations about the Constitution itself, whether it has served its purpose in terms of some of its provisions in that they were conceived at a particular point in time, and perhaps some of them may need revisiting, if not ultimately to be amended? I've heard conversations, and I know it's a long question, I've heard conversations recently that say even this whole concept of quote unquote, South Africa belongs to all who live in it. I've heard many people on my radio show on SAFM raising that and saying that perhaps it's time we revisit that.
It's not so much a long question as it is a hard question, because I was watching the show, obviously, as we were watching the news, and I was watching the Operation Dudula protest in front of the hijacked buildings, and I'm a property scholar, so I was watching this and thinking of all of the problematic things that were unrolling in front of me, thinking to myself, obviously there's no eviction order, and thinking of what the police was saying, that there's no correct eviction order, the evictions cannot take place, but also thinking to myself, as you've mentioned, that the only call to actually have people go and contribute to, ask for the Constitution review is that I've seen the clause exactly as you've mentioned. The Constitution belongs to all who live. South Africa belongs to all who live in it was actually to be amended, right? To have people submit to say that no, actually South Africa shouldn't belong to all who live in it. It should belong only to South Africans. So all that to say that there's obviously a very populist narrative going around that is very xenophobic, very along the lines of the Dudula movement, right? And to say that actually all the voices that we've been hearing, again, is the very populist narrative. So unfortunately, what I'm trying to say is there is a lot of energy in the very common movements, and what I am thinking right now is there is not enough energy in the other spheres of trying to actually look at what the problems that we're seeing right now. We've heard the interview of the grandmother who was speaking, the mama who was saying that actually she had this really awful moment where her building was hijacked, right? Her home. And unfortunately, this is probably true, right? And it's unfortunate, but in one of the hijacked buildings that I saw a mama, right, who was from KZN, and she's South African, and she was unlawfully occupying the building because she had nowhere else to go.
Right?
Unfortunately, and I was thinking to myself, but Sorry, just to quickly finish the point, that the problem is that there are poor people who do not have housing, and the people who should come to the table is the executive who should answer to the fact that there are people who are homeless and they should be contributing housing.
All right, I've got to thank you both. What an interesting discussion we've had this afternoon. That's Tanvir Jiwa, who is a constitutional law expert, as well as Mark Haywood, a human rights activist of long standing in this country.